You may be seated. Judge Griffin has joined the panel, and we're here on RUBRECHT versus Cone.
Good morning. May it please the Court, my name is Kristen Norris. I'm from Kynes, Markman, and Fellman, and I'm here representing Bernard RUBRECHT. I'd like to reserve 5 minutes of rebuttal, please. The defense in this case used a confidential settlement letter, select portions of a confidential settlement letter, to cross-examine Mr. RUBRECHT at trial. That not only violated Florida law, but in this case, by using the select portions, it left a distinct and devastating misimpression with the jury that Mr. RUBRECHT claimed and may have even collected hundreds of thousands of dollars of his damages from the driver in a crash that occurred a month before the crash in this case.
Was the letter ever made part of the record?
Yes, the letter is in the record.
But it was not introduced, correct?
The letter itself was not introduced into evidence.
Okay, so all the jury heard were the series of questions.
Right, that were elicited from Mr. RUBRECHT on cross-examination. The letter was attached to our brief so you can see the type of letter it was. It was a standard, candid settlement letter directed to the driver in the first crash. And by using this in cross-examination and using only snippets of it, the most damaging snippets, the defense was able to lead the jury to believe that there was some kind of specific position taken in the letter on apportionment, which was really the heart of the case. Now, as to whether the letter itself was introduced in evidence, the rule protecting the confidentiality of settlement negotiations, Section 90.408, is clear. It applies not only to the offers themselves, but also to any statements made in negotiations. So you couldn't get the letter in any more than you could get any portions of the letter into it.
Did they get to, I'm sorry, go ahead, Judge Palmer.
The questions that were asked in front of the jury
Yes.
were not related to offers of settlement, or they were related to allegations of factual allegations, right? Such as,
Taking a position.
did you take the position that you would have future medical losses as a result of the first accident for the rest of your life at $3,000 a year or $99,000 total? Yes. Right. Those were the nature of the question asked in front of the jury, right?
Yes.
So it had nothing to do with settlement negotiations. It had to do with factual representations as to damages, didn't it?
That's the way it was presented to the jury, that he took a position. It was left to the jury to speculate as to why he took that position or in what format. Regardless, what was really elicited to them was that he made these statements. And of course, those statements were made in settlement negotiations. And so, you know, that the substance of the statements are in evidence.
Let me ask you this. Let's say that the defense had a witness who had talked to the plaintiff, and that the plaintiff had told the witness that as a result of the first accident I had economic losses, that my future wage losses would exceed $158,000 as a result of the first accident. Mm-hmm. Okay, I mean,
Sure.
It's an odd hypothetical, but let's just say that hypothetically the plaintiff told some third party this,
Right.
not in the context of settlement.
Right.
Is there any reason why the defendant could not ask the plaintiff that question, and then if the plaintiff denied the assertion, introduce the third party witness to impeach the plaintiff?
No, there would be no problem with that because it was a statement made outside of negotiation.
The question itself,
Right.
as framed here, is not inherently improper.
If it were an admission made outside of settlement negotiations. But the point here is we protect settlement negotiations that they're not admissions.
Well, they never had to get to the introduction of the statement that was contained in the offer of compromise because the plaintiff admitted that that was the position that the plaintiff had taken, right?
But he had to, he had taken it in a settlement negotiation, and that is not an admission, as if he had just gone up to somebody on the street and started a conversation, and then he'd made an admission. That's different. And we recognize that, and we protect the settlement negotiations so that you can speak freely, you can take your best position.
I understand what you're saying, and if he had said, no, I didn't take that position, and then the defendant had tried to introduce the letter to impeach him, you might have a different case. But you've just told me that there's really nothing inherently improper about the question that was asked. It's just that had he denied it, the impeachment proof would have come from a protected writing.
Well, maybe I was not clear in my answer.
Okay, maybe
my
I wasn't clear
answer to
in my
your question was, if this was an admission made outside of the context of settlement negotiations, then this would have been a proper question. But what you say in settlement negotiations, and the case law is clear, is not counted as admissions. They're not used for impeachment. The Florida Supreme Court in the Salibi decision said there's no impeachment exception to this rule. There's no getting this in through the back door and cross-examination. You can't admit this evidence.
And this is because of Section 90.408, correct?
Yes, Section 90.408.
If that statute wasn't in existence, under the old common law, you would be able to admit the factual allegations.
Under the very old common law, before the rules of evidence and before Federal Rule of Evidence 408 and the state laws modeled on that, that was the case. They did not protect the settlement negotiations.
So if 90.408 does not apply to this particular circumstance, you lose on that point, right?
I don't see how it couldn't apply, but I mean,
because
clearly
it relates
my
to
argument hinges on
proving
90.408.
liability or absence of liability for the claim.
Right.
And in this case, it was not being used related to the claim that was the subject of the settlement letter, correct?
Well, it actually is related to the claim it was to prove the value or liability for the claim that was the part of the settlement letter. Because if they could prove that that claim was more valuable, then they proved that the claim in this case was less. And that's why the rule has been applied when the claims are related. To the extent that Mr. Rubrecht's counsel was able to negotiate a favorable settlement for these same injuries in the first case, the defense would have benefited from that. They could have sought an offset for it. So the two claims were related, and the case law is consistent that as long as the claims are related, and it was to the value of the claim. They were trying to show, look, the value of that first accident was very great, and the value of this accident not so much. So the rule applies as long as the claims are related, because you're going at the value.
The purpose of the letter was for the plaintiff to claim that the value of the first accident was great, correct?
Well, you know, this is a pretty candid settlement letter. So the purpose of the settlement letter was to try to solve one of the two cases that were involved. And I mean, this is kind of a perfect example of why you want to encourage these settlements. I mean, this first claim settled for a mere $10,000. But if Mr. Rubrecht's counsel could have even foreseen that anything he wrote in this settlement letter could be used on the larger claim or on the second crash against him by cross-examining Mr. Rubrecht himself, then there would have been no incentive to try to write that letter to settle. It would have been too risky. You know, that's why we have the rule. That's why we protect confidentiality. And there's certainly no case that has permitted this type of cross-examination on a related claim and affirmed on that. And the cases also recognize that this type of error is patently prejudicial. In the Salibi case, the Florida Supreme Court went so far as to say that this type of evidence, it's practically impossible to overcome, and it is reversible error. Other cases describe it as obviously prejudicial. It was particularly prejudicial in this case because by cherry-picking pieces of the settlement letter, they were able to show the jury that he may have claimed hundreds of thousands of dollars in damages from the first crash contributed to these injuries, and yet they left out that it settled for $10,000. In fact, all he asked for in the letter was $10,000. And this is, again, a candid settlement letter. This wasn't a hide-the-ball settlement letter. It disclosed both crashes. It detailed the total injuries, and it said, you know, please settle this case for $10,000.
Did you want to address your second issue?
Sure. The defense's violation of the rule against the settlement negotiation evidence was error enough to require reversal, but there was another unusual error that contributed to this verdict, and that is that the defense convinced the trial judge to take judicial notice of two sentences in an appellate court decision in a certiorari case. The defense's theory was that the sentences in this decision directly contradicted testimony from Mr. Rubrecht's surgeon and one of his key witnesses. That actually was not the case. There was no direct contradiction. The surgeon testified by deposition at trial, and he testified that it wasn't true that 100% of his income came from letters of protection. The sentences in the appellate decision didn't talk about all of his income. They talked about his income from his medical practice, which was limited to letters of protection. But in any event, this wasn't proper for judicial notice in the first place. Certainly some court records are proper for judicial notice, but that doesn't mean every sentence in every decision becomes a matter of undisputed fact. In fact, certain statements are hearsay when they're offered to prove the truth of the matter asserted, which was what they tried to do here. This couldn't be used as a substitute for proper cross-examination. Despite this, the defense was allowed to use judicial notice. It was the last thing the jury heard. It came straight from the judge, and then they hammered it in closing argument. They emphasized, this is a doctor with a lucrative practice, and this testifying for his patients is his life. So these two errors together really created the perfect storm for a flawed verdict. By using the confidential settlement negotiations, the defense tried to
What was the legal, what was the subsection of 9202 under which, or was it 9201? What was the legal authority for the request for judicial notice?
I'm not sure that I know the exact subsection, but I
Well,
believe it was
tell
the
me
court
substance of
records.
it. That it was a court record?
Court record.
Okay.
I believe so.
It wasn't argued that it was a fact that was generally known and not known.
Not to my knowledge,
Okay.
no. It was that it was simply a court record.
All right.
So to these two errors together, the defense used the inadmissible settlement negotiations to paint RUBRECHT as a deceptive and greedy person seeking a substantial double recovery, and then they used the judicial notice to say that his doctor was also a wealthy, greedy doctor involved in a bitter, contentious divorce, who was banking on a good settlement or a good verdict in this case in order to get paid. This clearly affected the verdict. There was overwhelming evidence that Mr. RUBRECHT had been severely injured in this crash. In fact, the defense's own CME expert agreed that this crash caused a permanent and severe nerve damage that resulted in Mr. RUBRECHT having to have the surgeries. His medical expenses were over $400,000, and the defense had admitted liability for the crash, and yet the jury returns a minimal verdict of $20,000 and a finding of no permanent injury. The errors in this case led to that verdict. They contributed to it. The defense knew how damaging this information was because they brought it up in closing evidence and hammered on it, and that error merits a new trial. Thank you.
You have about 7.5 minutes for rebuttal.
Good morning again. Hinda Klein on behalf of the appellees. On the first issue of the...
No, I don't want to talk about I don't want to talk about the second issue.
Okay.
What about, what do you say the statutory authority for the admission of the judicially noticed fact is?
90.2026. It wasn't judicially noticed as a fact. It was judicially noticed as a court record.
Record of a court.
Correct.
Well, it is a fact, though, right?
It was a fact as recognized by the court, I suppose.
But I mean, where did the court get that fact from?
Presumably from the evidence, yes.
Yeah, I mean, and the evidence varies from case to case, right? I mean,
Yes, it does.
Is that appropriate for the court to allow the interjection of a fact from a case A into an entirely separate case? Is that correct use of judicial notice?
I would not have done that. No, I think that was frankly gilding the lily. I don't think it was necessary.
I admire your candor. It's refreshing.
Thank you.
Your argument is that it really didn't.
It didn't matter. It did not matter in the context of this case at all. There was a significant amount of evidence on the issue of, first of all, on the issue of Dr. Nucci's potential bias in the case, because he freely admitted without objection that he did have a letter of protection in this case. But separate and apart from that, there was overwhelming evidence impeachment, both as to Dr. Nucci and also as to primarily the plaintiff. The plaintiff was his own worst enemy. He was combative, he was difficult, he was impeached on numerous issues. There was, although he presented a great number of experts, to the extent where the court said, if you present any more expert testimony, I'm going to have to grant a mistrial. But the experts just could not support the ultimate verdict that was requested by the plaintiffs, who actually asked for millions of dollars in this case.
Was the excerpt from the court's opinion the focus of the closing arguments?
No. Not to my
Was
knowledge.
it mentioned in the closing argument?
I don't want to say absolutely not. I don't believe it was. But I can't remember, honestly. But even if it was, again, in the context of the case, they found no permanency. And this was based on a great deal of evidence regarding pre-existing conditions, conditions that existed well before even the first accident in this case. He had complaints back to 1999 and 2003, and years before the accident there had been some communications with a doctor regarding potential back surgery. The biomechanical engineer testified that the force in the second accident, the accident at issue here, was about half of the force of a bumper car. There was only $900 in damage in the case, and the plaintiff had had a prior rear-end collision a month before this accident. There was an abundance of evidence ultimately supporting this verdict. While $20,000, according to the plaintiff, is a minor verdict in line of the fact that the jury found no permanency, that verdict was well supported by the evidence. Under the entire context of the case, all of the arguments raised here are harmless error. If the court has no further questions, I'll rest on our brief. Thank you.
It appears that there's really no dispute over the errors that occurred, and so that the argument has focused solely on harmful versus harmless error. So I'll be brief in my comments.
Was the excerpt referred to in the closing?
Yes, actually, it's at transcript 580. It's quoted in our brief on page 21. The defense's trial attorney said, "Now, you heard that Dr. Nucci has a lucrative practice, and he receives his income this way. This is his life. Is it any wonder that he's charging $50,000 for what we know is a 10 or 20-minute procedure, the first surgery? You've got to think about that. You've got to wonder whether some of the charges in this case weren't colored by the fact that he's going to get paid out of the proceeds of the lawsuit. It puts an entirely different light on this." Both of these errors were wrong.
But what came in from his own, admissions in his deposition? They asked him about that, right? About what percentage of his practice was related to?
Sure. There was some other information that he said. It wasn't a lot, and there wasn't a lot of questioning on that. So he said it wasn't 100% of his income, and then there really was no follow-up on that.
How much did he charge for his services in connection with this case?
I'm not sure that I have the exact figure, but there were 2 surgeries in this case, both of them done by him, and so they make up more than half of the over $400,000 in medical expenses that were this case. Mm-hmm. So he was key. I mean, he was key for two reasons.
That's a lucrative practice if he made that much money on one patient, right?
Right. Well, and I'm not sure what relevance is lucrative.
The jury could certainly view it that way, right?
Sure. I mean, they use this to impugn this witness.
Right, but I'm trying to get you to crystallize for me, what the harm is from the judicially noticed fact as compared to really what the jury already knew from the other evidence?
I think the harm is, and the case is recognized, that this comes directly from the judge at the close of evidence. It's got the imprimatur of judicial notice. The judge is telling you it's not coming from the witness. This was really proper for cross-examination of the doctor himself, and then we could have hashed this all out. But coming directly from, the court at the end of it, and then also this whole emphasis on lucrative. I mean, that really became the theme of their case. These people are greedy. This is lucrative. He's going to make a lot of money off of this. And yes, the jury knew some of that, but to hear that a court in his divorce case brought this out, I mean, it's pretty compelling testimony.
Did the jury
about
hear
this
that kind
keywitness.
of cross-examination of the plaintiff's expert, or did you have an expert that made a lot of money giving testimony on behalf of plaintiffs?
I'm not sure that I recall exactly. I don't remember.
I'm sorry, the defense expert.
The defense's expert.
Did you get into that with the defense expert?
I don't recall. I mean, the only defense expert at the end was Richard Allnutt, the biomechanical engineer. So I'm not sure that there was much emphasis on that on their side. Of course, the defense's CME expert ended up testifying consistent with Mr. Rubrecht's position. So I'm sure each received some level of cross-examination on how they earned their money, but it wasn't really featured except with the surgeon in this case. The test here under the Florida Supreme Court's decisions is an error is harmful if it is reasonably likely it affected the verdict. And on the settlement negotiation information, the cases are consistent. It's obviously harmful. It's patently prejudicial. And the Salibi decision says it is reversible error. This was a case in which there was overwhelming evidence in Rubrecht's favor. It wasn't even a close case where this might have tipped the scales. There was a lot of evidence, including the defense's own CME. It's not every day you get to go to trial with the defense's expert agreeing with your best position that this crash caused a permanent injury and you couldn't apportion. You had to put it all on this crash. So the error was undoubtedly harmful. It affected the verdict, and we asked the court to reverse and order a new trial without these errors.
Thank you. Next case.